We're excited to welcome you to our next panel, ODR in the Courts. We've got some great presentations and very short time for this important topic. We don't have a moderator, so I'll be presenting briefly our speakers, and they will introduce themselves as they go about their presentations. So our first speaker will be Judge Thian, who's a principal district judge in the State Courts of Singapore. And we're going to hear about ODR in Singapore. Then I will be presenting. My name is Ayelet Sela. I'm a professor at Ilan University, and I work on ODR for many years, and excited to be here. And finally, we'll hear from Nicolas Lozada and Juan Camilo Girón, who will talk about ODR in Colombia and their company Redec. So please.
Thank you. Just give me a minute. I'm trying to see. Okay, wonderful. Good morning, and thank you very much for having me. And over the next, I think, 10 minutes or so, I shall share with you Singapore's budding experience in leveraging on Gen AI to enhance access to justice. And this is particularly important for the various judicial tribunals and specialist courts in Singapore, where we see a lot of self-represented parties. Now, to explain why I say that, let me first set up the kinds of cases which these tribunals and courts deal with. The community courts and tribunals are part of the state courts in Singapore, where most of the criminal and civil cases are filed and heard. About more than 90% of them actually heard in the state courts. Now, in Singapore, unlike in the United States, where you have separate state and federal jurisdictions, we have a unified court system. And almost 40% of the civil cases filed in the state courts are in fact filed in these tribunals. Now, these tribunals hear civil disputes arising out of economic transactions, daily interactions, and personal relationships which have gone wrong for one reason or another. They deal with all manner of disputes which people may find themselves embroiled in as they go about their daily lives, at work, at home, with neighbors, or when they purchase goods and services, such as on e-commerce platforms. Now, the central feature of the cases dealt with by these tribunals is this. Now, more than 99% of the litigants in these tribunals do not have legal representation. This is in part by legislative design, which prohibits lawyers in tribunal proceedings by default. Now, there are 4 tribunals in this cluster. The 5th one you see is actually part of our criminal jurisdiction, so I will not go into that today. Now, the Small Claims Tribunal, which is similar to the Small Claims Courts, which we have heard about this morning, or the SCT for short, deals with contractual claims of up to $20,000 generally. They deal with provision of services, sale of goods, and even landlord and tenant disputes. The Employment Claims Tribunals deals with unpaid salary claims and wrongful dismissal claims and several other statutory claims. The Community Disputes Resolution Tribunal actually deals with conflict between residential neighbors, from cigarette smoke to even chirping of pet birds, which can be quite loud, as well as loud clang of mahjong tiles. So a wide variety of neighbor disputes in Singapore. And as some of you may know, Singapore is a very small island nation, and most of us actually live in very high-rise blocks. So we can get get on one another's nerves quite often there. So this tribunal actually sees a lot of business. We have, of course, the Protection of Harassment Court, and as the name implies, it deals with harassment of all sorts, including online harassment and stalking. Now, over the years, the cases which have come before these tribunals have actually grown more factually and legally complex. There's also a greater awareness among our citizens of the avenues to seek legal redress in the courts. And actually, many people prefer, either by choice or perhaps by necessity, to pursue or defend their claims on their own without a lawyer. Now, this has resulted in a steady increase of the number of cases filed in these tribunals in the past few years, as can be seen in this chart. So you can see there's quite a dramatic, I would say, percentage increase year on year in terms of the claims filed in the tribunals. And we do expect these numbers to rise. Now, bearing in mind that the majority of these litigants are self-represented, a key concern for us has been how to ensure that they have meaningful access to our tribunal justice system and are able to actually participate actively. Now, self-represented persons face various challenges in access to justice, which we call the justice gap. And there are 3 dimensions to this justice gap: the physical gap, the resources gap, and the literacy gap. And with this increasing rise in caseload and greater complexity of cases, the need to address these gaps and level the playing field for self-represented persons becomes ever more critical. Now, our focus has been on bridging the literacy gap and resource gaps, because as you know, Singapore is a small country, so the distance from the courthouse is not really a big issue here. Now, in the specialist tribunals, the legal procedures are kept simple and streamlined, undergirded by a proactive judge who plays an active role throughout the whole judicial process. Costs are kept low, and legal representation is generally prohibited. We also have court-annexed facilities and programs, as listed on this slide, to support our court users. We have also tapped on technology to help our court users navigate the tribunal justice process. We have what we call a Community Justice and Tribunals System, or the CJTS, through which we have completely digitized and moved the entire case filing and case management process online. The CJTS is an end-to-end filing and case management process, which is easily accessible through our Citizens National Identity account. It allows court users to do everything online, from case filing to negotiating settlements online to making court applications and requests. Now, I've set out on this slide some of the detailed features of the CJTS, as well as a screenshot of what our CJTS website looks like. Now, in 2023, we started to look at how we could harness Gen AI tools to support our objective of facilitating timely and quality access to justice for all. Now, I will quite quickly take you through some of the tools which we have been using or experimenting with. Now, there are 2 types of tools. The first type directly helps self-represented persons to prepare their cases and participate in the justice process more effectively. Now, the second type of tool actually assists the judges and our court administrators in their daily work. Now, one such tool which we have developed, you can see on the screen, is a collaboration actually with an American legal startup company called Harvey AI. And this is in the area of translation and case summarization tool, which is now used in our SCT, or small claims proceedings. Our court users can now make use of this Gen AI-powered tool to translate documents filed in the case management system from English to Chinese, Malay, or Tamil, which are the commonly used languages in Singapore. Now, this ensures that the language barrier does not impede a litigant's ability to comprehend and effectively conduct his case. The case summarization tool also allows litigants to summarize their case documents into clear and easily comprehensible summaries. Litigants can select the case documents they want the tool to consider in generating case summaries. The summaries generated also outline the main points of the other party's positions, the case theory, the key evidence, and also helps to identify legal and factual issues. Now, I have actually set out some screenshots of what the case summarization tool can generate to give you a flavor of how it looks like, and also it distills key points of the case, which I will have uploaded on the slides, which you can take a look at it later. So as you can see, it can actually also generate an AI's analysis of the strengths and weaknesses of each party's case. Now, given our, I would say, initial success in this area, we do have intention to develop similar capabilities for the other tribunals. We have also developed in-house tools for our judges and court administrators to support them in their work, which I have listed here. The case summarization tool, which I have talked about, is also available for use by our judges. Now, aside from our collaboration with Harvey AI, we have also developed a number of Gen AI tools in-house using Gen AI products made available and developed by our government technology agency of Singapore, which centrally actually manages a lot of the Gen AI tools used by the Singapore government. And let me just touch on them very quickly. The first tool is what we call the Lex AI, which is an AI-powered legal research assistant. Lex AI was developed in-house by one of our young judges. It is used internally by our judges in small claims proceedings and really focuses on issues relating to discontinuance of claims which are outside the jurisdiction of the SCT. Now, why we have picked on discontinuance of claims, because we noticed that quite a high percentage of claims actually filed in the small claims tribunal, although it's not within the jurisdiction of that tribunal. It actually helps to streamline the research and drafting process and significantly actually assists our tribunal judges to draft reasons for discontinuance in any given case. And this actually significantly shortens the judge's research and drafting process. Now, the next two slides are what the Lex AI screenshots actually look like. Now, another tool we use is Smart Compose, which is a writing assistance tool. Now, this tool is designed to help public officers draft faster, more thoughtful, and professional responses to citizen inquiries. It generates replies based on a few parameters. First, you can actually choose the reference materials to help you generate the response. Secondly, you can also, calibrate the tone used for in your reply. For instance, you can be empathetic, it can be polite but firm, or you can be just very straightforward. Third, the length of the reply can also be adjusted. Our registry actually receives a lot of queries and requests every day, so Smart Compose has worked wonders in terms of productivity with a 40% reduction in processing time. So these are just some screenshots of this Smart Compose tool that we use. Now, finally, we have what we call a judicial note-taking assistant. Now, this judicial note-taking assistant helps to reduce the burden of the judge in relation to note-taking. And essentially, it helps translate audio recordings into text with a working level of accuracy, which the judge can actually then vet and then finalize as the official transcript. Now, I shall conclude with some initial reflections on our experience in the use of Gen AI so far. Now, this digital age, technology and Gen AI offer immense potential, of course, in terms of enhancing self-represented persons' ability to meaningfully access and participate in legal proceedings. They can also enhance our ability in the judiciary to deliver better quality justice. Now, in the coming months and years, given the positive or initial positive response to Gen AI, we plan to progressively expand the use of such tools across the specialist tribunals. But as we do so, it is also important for us to be mindful that the use of AI, for all its promise, as our earlier speakers have also alluded to, it carries risks. One such risk is of relying wholly on Gen AI-generated content without critical scrutiny. We're also aware of horror stories which AI has hallucinated, produce legal analysis based on case laws and statutes which actually do not even exist. We have seen this as well in Singapore. Now, while legally trained persons may be able to pick up these errors, the lay person may not, so it is imperative that we do not take anything generated by AI at face value. And we need to make sure that the judge actually does the check and critically analyze such Gen AI produced content, and that remains paramount. Now, another thing we have noticed is that self-represented persons are already beginning to use Gen AI, such as ChatGPT, during court hearings, for instance, to help them draft legal representations, or even their own witness statements or affidavits, which can also be of concern, of course. Now, while we have put in place guidelines in the use of Gen AI by court users, including lawyers for that matter, now these guidelines, of course, cannot practically cover all aspects of Gen AI usage or even abuse. Now, we also need to make sure that our judges, administrators, are well trained on how to use Gen AI to ensure that the tools deliver the intended benefits while being aware of the downsides of the use of Gen AI content. Now, in the final analysis, the use of Gen AI tools is fast becoming an important strategy in the administration of justice in Singapore. With that, I conclude my presentation. I hope you found it useful. Thank you very much.
Thank you. So we'll try to quickly move to the next one. No, if you can do that, that would be great.
Okay, let's see. It should be this one, maybe?
Yes.
Okay.
But if you can start first.
Yeah, sure. Yeah. Did that do it for you?
Yeah, perfect.
Okay,
Thank
great. Sure.
Okay, so we've talked a little bit about the present of time of online courts and what is currently being done. What I'd like to present here today is somewhat of a vision for the future of what online courts may look like. And there's probably no better place to talk about the multi-door courthouse than right here at Harvard University. This concept, the vision of a multi-door courthouse was born here. Professor Frank Sander introduced it in the mid-1970s. And the idea is basic. There are many different types of disputes, many different types of needs that different disputants have, different capabilities, different goals as they go into the court system. And courts should be able to direct disputants as they enter the courthouse into the suitable door, the particular dispute resolution process that would benefit them, that would help them resolve their issues depending on what their interests, goals, capabilities, resources are. And that door could include adjudication, mediation, arbitration, early neutral evaluation, guided negotiation, and also increasingly different types of processes within courts as process pluralism has become more prevalent in courts these days. The challenge, even as this vision was originally introduced, was, well, how are we practically going to be able to direct these disputants to the different doors? How are we practically going to have different dispute resolution processes hosted within courthouses? And how are we practically going to triage those people as they come into the court, into the given door? Now, ODR, and online courts as ODR grew into courts, was increasingly thought of as a good solution for this problem, right? We could have multiple virtual doorways in courts where disputants could resolve their cases. And we could help them self-sort into these doors, or maybe we could help design some sort of a system that would sort them into these doors. But as years have passed, the fact of the matter is that we could not realize the multi-door courthouse vision, even with ODR. And even in present days, it appears that we are having a hard time finding the right cases to go into particular ODR processes. And we're also having a hard case, of course, sorting regular standard court proceedings as people use them. And I think this difficulty is both a practical one and a normative one, because we have still not developed a good normatively defensible basis for sorting people into particular dispute resolution pathways. Now, in the interest of time, I'm not going to reiterate what Judge Thian already discussed, which is the access to justice crisis that is prevalent in many court systems. Here in the US, it is really a tremendous crisis because at the background of this sorting into courts problem, there is also a huge demand by users of the court systems who are having a hard time getting a remedy through a court process. And this is heightened as we are living in an era of representational asymmetries that essentially render courts, for many people, an unusable forum to address their cases. Again, technology is hailed as a way to resolve this challenge, but for many years now, or at least since COVID-19 has come into our lives and has changed the way digitalization works in courts, this vision is still not sufficiently realized. So this is a rounding challenge. We have many doors, but we can't really fit the forum to the fuss. And procedural pluralism is not realizing its promise. We do have some crude allocation proxies, right? We do that with general civil proceedings or criminal proceedings when we have different procedural pathways. So case type, claim value, maybe other crude proxies that are usable. They're easy to operate administratively, but oftentimes they are not sufficiently correlated with the actual attributes of the case, with the actual needs, capabilities of people who are involved in this case. So they fail to adequately account for the complexity of the case, for evidentiary needs, for the self-efficacy of the participants in this process, relational dynamics, even the settlement potential within a particular case. And what we see, especially given representational asymmetries, that we can't really rely on parties to self-sort. So we have procedural abundance, but ineffective allocation. And this has come to be a real problem also in court-connected ODR, because even though we've had court ODR programs implemented for over a decade in courts, we still see very low uptake, so very low usage of ODR in courts. And we also see quite limited effectiveness of ODR in actually resolving cases once they do enter the ODR process. Now, there are many reasons for these challenges. I'm not going to go through them since we don't have much time and we've started late. So I'm going to focus on just a couple of them. One is that there is no real integration of ODR into the dispute resolution process within the courts. So this is a satellite process that parties have to usually voluntarily figure out how to use. Even when it is mandated, there aren't really sanctions for not using it. So it's hard to make users participate. I want to credit Jennifer Shack here, who's done a tremendous work in a study that mapped some of the barriers that prevent self-represented litigants from using ODR. I'm going to focus also on perceptual barriers. So these are all these ideas that people have or don't have about ODR, don't have in the case when they're not even aware that an ODR is an option. As far as effectiveness is concerned, again, even though we have a tiered process design, typical in court-connected ODR, where parties maybe self-diagnose, then try to negotiate. If that doesn't work, they move into mediation. And if that doesn't work, they move into adjudication. That tiered process design is still insufficient. It is not enough. And for some users, there's more legal help or self-help resources that need to be provided. Some need some coaching on negotiation for them to actually be effectively negotiate using the platform. Others may need some benchmarking or reality check that is not provided within this process. So at the end of the day, even when parties enter into ODR, they oftentimes don't use it effectively. This has negative impact, of course, on outcomes, especially when we think about high-volume civil litigation, where there are just insufficient demand for using these ODR processes. And of course, it means that we're not allocating resources within courts in an effective way, in a way that is actually impactful on outcome, on access to justice. And finally, it's also problematic in terms of procedural experiences, because those disputants who do enter ODR and can't figure it out also have failed expectations, failed procedural justice experiences. So just as a sneak peek, this is from a project that I've done as part of the Rody Center on the Legal Profession at Stanford University in collaboration with the Los Angeles Superior Court. Here are some stats about the usage of the court's two leading ODR programs in unlawful detainer, that's eviction in California, and small claims. And we can see that those ODR programs are used in less than 1% and 3% of the cases. This is case filings, respectively. When we look at the effectiveness of these processes, at the rate of the cases where agreement has actually been reached, we see that the effectiveness of these ODR programs is still quite limited. And I can tell you just from interviews that we've conducted with some of these mediators that in fact many of them are actually resolved by phone and then reported via the ODR system. So it's not the ODR process that is getting those cases resolved. So we still have a serious access to justice problem, and there's still a serious institutional legitimacy concern for courts who are trying to implement court-connected ODR. The programs are underutilized, and at the end of the day, it means that courts themselves are underutilized and less effective than we want them to be for participants. And of course, these challenges will become heightened as we see AI increasingly incorporated into legal proceedings, both on the supply side as plaintiffs are filing more claims into court, and both in the court internal system utilization of ODR, as we've just heard, because increasingly we're going to have different levels of court resources that are allocated to different cases based on some AI mechanisms that are implemented within them. So appropriate allocation of cases of court users into proceedings becomes critical. And it is increasingly critical in those cases that are dominating the dockets of courts, debt collection, evictions, many family law cases, foreclosures, and other high volume case types where we see not only high rates of self-represented litigants, but also very high rates of default judgments where we simply don't have all parties at the table. So what I want to propose here in my really last 40 seconds is that we can do a better job triaging cases into courts, and we can do a better job triaging cases into online proceeding within courts. And I think many people in this room will agree that over the next few years, this distinction between courts and online courts is going to become less and less significant as more e-filing, e-case management, virtual hearings, text-based or paper-based hearings are being integrated into the regular run-of-the-mill case management in courts. So this is really a broader claim. It's not just court-connected ODR, it's online courts broadly understood. And we can think about sorting cases into proceedings in within a spectrum with two end points. One is hard triage, where courts assign cases into proceedings based on some data that they collect. This could be data gleaned from intake, data gleaned from case management systems, and also data gleaned from scanning of case documents now that we have better capabilities of AI reading those texts. On the other end of this spectrum, we have just open choice, minimal guidance that's provided to litigants, and litigants can just figure out themselves how they sort into cases. I personally think that we don't know which of the sorting mechanisms along this spectrum is the better fit for particular case types, for particular disputants, for particular circumstances, for particular power asymmetries between litigants. And the best approach forward for courts is to try, to test, to actually experiment with self-sorting or hard sorting, right? Hard triage of cases into different procedural pathways while measuring rigorously the impact of the sorting of cases into these procedural pathways measuring not only typical court metrics such as efficiency, time to resolution, the number of hearings that have taken place, but also to what extent did parties utilize legal help in the process? What it was the procedural justice perceptions or fairness perceptions of participants in this process? What indicators do we have? What proxies can we use for increased guidance or assistance that should be provided to some litigants as they make these decisions? So empirical evidence here will be critical. Systematic evaluation is critical. And if there are any representatives or courts here in the audience, I would love to continue the conversation about how that can be implemented in practice, what kind of data needs to be collected. And in the Q&A, perhaps we can discuss some of the ethical challenges that are associated with adopting this approach, as well as perhaps governance principles, building on Leah and Dan's presentation, for how to best run this vision in practice. So thank you very much, and I look forward to the discussion. Stage is yours, guys.
I think it's coming.
So we need your other computer, or?
I think it's.
I think calling is going to play.
So we've already discussed the present, a really good present of what we've seen in Singapore, and the future, what Ayelet is proposing, what we can do to better triage and sort and classify cases for online courts. We're going to discuss now challenges, particularly challenges for emerging countries. So we're both, Juan Camilo Girón and Nicolas Lozada, we both work at Redec. We are a Colombian startup focused on digital justice and the promotion of ODR in Latin America. And currently, we are working in the issuance of the 4-year sector plan for justice in Colombia. So the Superior Council of the Judiciary has asked us to support their digital transformation program and to do this 4-year plan into what can be done in the next 4 years. And of course, there are a lot of upsides, but also downsides. And we want to discuss some of them, what we found so far as a case study of what we can do in Colombia, but I think it was already mentioned, Botswana and other emerging countries around the world. So let's start with the upside.
So one positive thing that Colombia has done is that it is investing in AI for its judicial system, investing in terms of legal, but also economic resources. We can find in the legal sector that Colombia was the first country in the world who adopted UNESCO's AI guidelines for the judiciary. That was in December 2024. Additionally to that, in the same year, 2024, the Constitutional Court made a ruling, the ruling T323 of 2024, that established and confirmed how AI can be used in the judiciary, both for parties, but also for judges, making it clear the step-by-step on when to use it and how to use it. Finally, bills are being before Congress right now. In 2025, AI regulation bill was set in the Congress, making a path towards the implementation of AI in the judiciary and in different sectors in the country. Now, in terms of economic, Colombia has a national AI policy in which it's investing from now on until 2030 more than $100 million in implementing AI in the judiciary. This, you might tell, oh, it's a little sum, but for Colombia, it's a big one.
But of course, there's always a downside to it, and it's that we have this a lot of investment on artificial intelligence, but most of the digitization processes being undertaken in Colombia are being improvised. And that's a reality that we're facing. There's a huge lack of governance. We have over 90% of judges that are using AI in rogue manner. So they're using whatever model they can, and they're drafting. We have a lot of cases with hallucinations, cases of false sources, because of course there's an efficiency linked to using AI, but they are just using it in whatever way they can, even dismissing ruling T323 of 2024, as was mentioned before by Juan Camilo. So only 30% of people, of judicial officials admit their daily use, but they're using it daily, even if the guidelines are still very either obscure or hard to understand. So those guidelines are not binding enough for judges to really apply them in their day-to-day work. And there's no legislation, as was already mentioned. So we're using artificial intelligence and we're using technologies that are not being allowed by the judiciary, but are having a huge impact, sometimes very negative one, on the users, on the citizens.
One other positive aspect is that in 2022, after the COVID-19 pandemic, Colombia stipulated the use of ICT in the judiciary proceedings and allowed virtual hearings in its judicial system. On top of that, in 2024, Colombia established access to justice as an essential public service. So numbers are very clear and figures are. We see that 80% of rulings in Colombia are being led by virtual proceedings. That's around 1.1 million cases. Additionally, 59% of the judiciary employees interact every day with AI tools, advanced AI tools. And tracking of cases, around 2.6 million cases are now being operated under electronic case management. So we can see that virtual justice is no longer experimental, but a reality in the country.
But there's a but, right? There's a downside, and then the virtual implementation of justice does not account to our reality. In many occasions, the platforms are not working properly, so they have collapsed, as it happened very recently in April 2026. And even though with the ease of using online proceedings, there's a growing demand, over 145% on demand over the last decade. The use of hearings is what we call in our work with the Judiciary Council, what we call formal substitution, meaning that all of the procedures that used to be manual are now being done by virtual hearings or by email, which doesn't really account for the benefits that come with, of course, ODR. And then we have a huge digital divide in the periphery. So Bogota, Medellin, the main cities of Colombia, well, they have very good internet access, but what happens in the Pacific or in the Amazon? There is still a huge digital divide that affects those communities that don't have access even to internet, less so to online or judicial resolution. So what happens at the end is that the public trust on the judiciary is very low. Only 23% of people trust the justice, even though we have virtual hearings, we have submissions by email. So there's still a huge gap that we have to bridge.
Colombia has implemented different systems for judicial data. We can see that Colombia is currently having a national data governance framework. This is helping not only having justice like closer to parties, but also the judiciary itself. The Superior Council of the Judicature now manages different major transactional systems. We have around 3 or 4 transactional systems in which parties can interact, and both parties and judges are always there submitting and filing different documents in their cases. Other courts, like SIC, have introduced different regulations in which they're saying you can use AI, but these are the step-by-step and how to use it and making it binding for parties.
Again, there's a but. So what we've assessed so far is that there's this metrics and data blindness. So the metrics and the quality of the data that we're gathering with all of those systems that Juan Camilo mentioned are still of a very low quality. Most of the data that is being submitted to the Superior Council of the Judiciary is self-given or self-presented by the judges. It means that there's also a perverse incentive for judges to actually submit whatever is convenient to them and to keep their current workload. So we need technology to be involved in this, but of course, taking into account our statistical governance, we are still below the minimum maturity level for safe, automated, or the proper implementation of data analytics. And then many of those records are now stored in separate Excel files. So isolated Excel files being submitted by judges that extremely difficult to manage and to get real and data that can be useful for proper policy making and decision making by the directors. So, so we have pros and cons. In conclusion, I believe that justice must be redesigned, and we really have to implement judicial ODR. If we implement ODR, it will be much easier for us to have proper dashboards to overcome that data blindness that we're facing, to have more governance on the use of technology and artificial intelligence, because you will have a platform where you can see what's going on, and that where you can have your money better invested, because there's a lot of money being invested, but we are not seeing the results. People do not trust the justice. And as Richard Susskind has stated in his book, Online Courts, you can't change the wheel on a moving car. And that's what's been happening to Colombia. With the coming of the pandemic, Colombian system was forced to do changes, but they were mostly improvised. So we need to move from virtual hearings or formal substitution to justice to proper online assessment, facilitation, and judging, as has been proposed earlier. I believe that the Singapore model is wonderful. We're also exploring Estonia, and we're trying to get as much collaboration as we can. So the goal is not to automate old court procedures, but really to make changes, to stop the car and really do changes that are badly needed in our system.
Another conclusion that we found and we really believe is that AI is a tool for human-centered judicial decision-making. It's important that before judges start using AI, they need to be certified as AI users. We already saw that it's almost 60% of judges use AI every day, but they don't even know how to use it. They're just using it because they found that what they need is to start reducing procedural times and start reducing their workload, and that's how AI is helping them. They need to change what they know as a fact finder by being a supervisor. AI will help them in their operational workload, but they will focus on what's important, the substantive part. AI is going to reduce initial subjectivity, but judges and the judiciary needs to have a human oversight in the trials. And AI should be consolidated as an epistemic intermediary and as an ally, so judges can focus on the substantive part and critical analysis of their cases.
So, in short, hybrid ODR is the key. I think that has been already presented in this panel. And it's key particularly for emerging economies. Many of the challenges that we're facing can be solved through this gaining of trust via technology and online dispute resolution platforms. If we manage to get this, actually trust of e-commerce in Colombia was very low even 10 years ago. And then with the proper implementation of technologies, now people are using more and more e-commerce. So we can do the same with justice. And I think ODR is the key. That's what I've been trying to propose and to advocate for in our system. But then we also need to get it closer to the citizens, and it has to be centered on the human, on the user at the end. So this hybrid model has to be tested against our own current socioeconomic reality. We cannot really change our conditions. We have to take them into account to properly implement the system. So we cannot really import the Singaporean or the Estonian system into our own. We have to take into account our idiosyncrasies and our reality. So we have huge court delays in Colombia, sometimes of years, decades, just to solve a case. But I believe if we do the right combination, starting from little to bigger programs, we'll be able to change this reality and have this leapfrogging change that we're looking forward to. Thank you very much.
So it's a really bad idea to keep the audience away from their lunch break. But we'll take maybe just 2 questions since we started late. And hopefully we can continue over lunch.
Thanks to the panel. Very, very informative. I would offer another case that changes the conclusions in all 3 that were presented, which is the Canadian story of judicial dispute resolution, JDR. Because it starts with, as the judge did, the question of what do we want dispute resolution to contribute to justice? And if you're saying there's something alternative to adjudication, what is it and how does it establish justice? And in the Canadian experiment in Alberta, one of the areas of Canada that's been doing this for 20 years, the parties, which are represented by counsel, come into the court and the tribunal management says, do you want adjudication or would you like some form of mediation? And the parties say, we would like mediation. And the judge who is assigned is presumed by the top judge to be capable of providing mediation. So that judge and that case becomes mediation. The mediation, if it fails within a specific period of time, starts over with a new judge. They don't give away anything, and that judge does not then hear the case. All of those proceedings, apropos of what you've been saying, are secret. All of it is confidential. The cases are not decided by precedent. The cases are settled. And if they're settled to the satisfaction of the parties, there's no evaluation relative to some standard for that kind of case, for those kind of people. It's settled. And it's enforced through a private contract that the judge approves that the parties make to embody that agreement that they've reached. There's no court record. Nothing becomes a precedent because the presumption is that justice requires a different outcome in every case, that the rule of law is less important than justice as seen through the eyes of the parties, although they are represented by counsel. And in JDR, counsel don't speak. The judge is the mediator, manages the conversation, lets the parties talk with their counsel separately, but then brings them back. And the parties are face to face. The judge steps down from the dais, takes off a robe, and becomes a mediator. In the U.S., we have court-annexed mediation, where the judge says, don't take our time. Go see a private mediator, even down the hall, which is questionable, but in the court building. So they've chosen which mediators. My sense is we need to be defining ODR relative to what we think justice provides in alternative dispute resolution. And is that really a function of whether precedent is continued to be served for similar people in similar situation, or that the satisfaction of the interests of the parties is resolved the way we would do in mediation in general? And we just need to be training some judges to be able to mediate. They retain all the status of the judge, but they are able to mediate. And we can certainly use various forms of AI, and they are, to assist the judges in their preparation. But we're very conscious of your last points in that Canadian story. This is really something that Canada has done for several decades. Because all the materials were confidential, I wrote a book with the Chief Justice of the Alberta Supreme Court in which he asked the court system to give us access to 10 cases from beginning to end and after. And so we have documentation during and after those cases, but we don't have data from the whole system. And we wouldn't want ODR to provide the kinds of evidence you're talking about.
So I have a response to this. I don't know if you all have one. I think that from a policy perspective, it is very problematic not to have data about those impacts. And from a system design perspective, we can be critical of the role switching of judges between mediators and adjudicators, and there are issues related to that too. The only way for us to actually be able to evaluate it is if we do measure what is happening in those cases, because maybe some of these settlements are really unfair to some vulnerable participants, and our reliance on having a judge as a mediator is not a good enough proxy for ensuring good outcomes. Maybe there's selection bias in the types of cases some repeat players are willing to settle, because these are cases that would make bad law for them, and so they don't want them to become president. There are a bunch of policy-related issues that are underlying this decision to just mediate those cases based on parties' agreement, and on whether that should be done under the auspices of judicial mediation. And so I don't think it is so straightforward and that we have a magic solution. I think just as with any other procedural design choice that we're making, we need to hold courts accountable to what are the outcomes, what's down the line for these proceedings. And so it's true for online proceedings, but it's also true for judicial mediation. Do you have any other responses?
Just to add, in fact, when we were developing the various dispute resolution options, we did study the Alberta system. And I think, like in Alberta, I think in Singapore, we have taken quite a pragmatic approach. So judicial mediation is not just court annex, but we actually weave it into the case management process itself. And in fact, if you see, even in our legislation, mediation is almost mandated as a step that you have to take. So all our judges are actually trained in mediation, but like it in Alberta, if you are the one doing the mediation, you of course cannot hear the trial. Somebody else will hear the trial. But we also know that there are quite a lot of philosophical or ideological variation in terms of one's thoughts on how a judge, whether and how a judge should mediate a case. So I just wanted to tell you that.
I fully agree with what was said. So in Colombia, there's even the procedural legislation does not account for that conflict of interest. So judges in Colombia are allowed to hold trial in the same case that they have mediated. That's also part of a procedural requirement according to our legislation. So the Colombian legislation does not distinguish that. And I agree with Ayelet that it will be very useful to have proper metrics for that. If it's the judge who reports whether it was successful, or whether parties didn't want to reach any agreement, or many judges in Colombia, they just, in the mediation stage of the procedure, they will just say, okay, do you guys have anything to say about the agreement? No, we move on. And they would rather have a lengthy procedure, years perhaps, rather than trying to encourage parties to agree. So that's something that we should look into, and then metrics and data should be really useful for that matter.
Maybe we'll have one last quick question. Yeah.
From a judge.
Hi, my name's Yvonne Campos, and I'm from San Diego, from the Superior Court of California. Every time I listen to these types of discussions, I have to say that you are assuming that you have two different rational parties. And I have to tell you that in the reality that I live in, the people that walk through the door, there are not too many rational people. They are emotionally strung out, stressed out, and especially where legal systems are having to try to address economic failures. And so I just say that to share that I like pragmatic approaches, because it brings some kind of closure or finality to something that would just continue to be a toxic dispute. And sometimes good enough is good enough.
Yeah. Anyone wants to respond first?
I just want to say we should exchange email addresses because we have the same issues. Yes.
So just to quickly respond to this, I think that one of the issues is, I mean, I completely agree, but I think we have still not figured out then what provides a good response to that challenge. Is the good response hand-holding court users through a very structured process and essentially making a decision for them, what would best serve them in this situation? Or is it letting them to maximize or optimize their autonomy, self-sort, make procedural decisions because they're able and capable of doing that? And I think we have a lot of assumptions as participants are getting into these proceedings, and we are not basing them on actual data. And I want to top that with the idea that not all disputants are the same, and you are probably seeing in your court particular disputants, the ones who have reached court, the one who have reached a hearing. But in fact, the majority of them are ones that would not enter your courtroom. And the question is, how is the system serving them? Could there have been an earlier intervention that would have empowered them to do more with what the court can offer them?
We'll talk.
With that, we will conclude this panel and we'll see you over lunch.